Okay, let's get you the news in detail. First, beginning with the top story at this hour. The Supreme Court has granted interim bail to Gujarat activist Teesta Setalvad for allegedly fabricating evidence to frame innocent people in the 2002 Gujarat riots case. Setalvad's interim bail comes after over 2 months as she was arrested in June. Setalvad has to in fact surrender her passport with the trial court till the Gujarat High Court decides on her regular bail plea. The bench also said that the High Court should have considered her plea for grant of interim bail. The Gujarat government, in fact, argued that Setalvad had quote-unquote maligned the entire state and the High Court by seeking special intervention by the Supreme Court. And the Gujarat government had also appealed to the Supreme Court not to accord any preferential treatment to her. What are the charges against Teesta Setalvad? Hurting religious sentiments, forgery, fabricating evidence and criminal conspiracy. However, the court also said that these are not charges under UAPA or under any terrorist act or arms act. And the activist, being a lady activist, deserved to get bail. The court said that Teesta Setalvad is entitled to relief of interim bail. So what exactly did the Supreme Court say? Let's put that out. The Supreme Court said on Teesta's bail plea, why was bail plea listed late in Gujarat High Court? Secondly, it said Gujarat government made Teesta an exception. Further, it went on to say that Teesta has been in custody for more than 2 months, remember, without a charge sheet. Also pointing out that police had enough time to interrogate her. There is no need to actually retain her in custody. Further saying offences listed are normal IPC offences, not under grave offences like UAPA. High Court should have considered the bail plea and not postponed it, not adjourned the hearing for another 1.5 months. So the reason why was the bail denied in the past is something that the Supreme Court questioned. Let's also remind our viewers that this is not the first case of an activist being held in jail for a prolonged period. Father Stan Swami, 84-year-old priest and tribal rights activist accused in Bhima Koregaon violence, was jailed in 2020, died in 2021 while bail plea was pending. Remember, he is someone who died while waiting for the bail hearing. That is the level of delay that we are talking about. Varavara Rao, 82-year-old poet and activist accused in Bhima Koregaon violence, languished in jail from 2018 to 2022. So another senior citizen who languished in jail for a very long period of 4 years. Next, let's put out Omar Khalid, student activist accused in Delhi riots in 2020. In jail since September 13, 2020. Bail hearing is ongoing in Delhi High Court. There's been no conclusion so far, so he continues to be in jail. Siddiq Kapan, journalist charged under UAPA linked to Hathras case, jailed since 5th of October 2020. Bail hearing ongoing in top court. Yet another case of Hani Babu, who's a professor of Delhi University, accused in Algar Parishad case, in jail since 8 July 2020, denied bail by an IA special court. The reason why we put these cases out is for viewers to see that in all of these cases, there's been a similar pattern of inordinate delay of bail hearing. So the question is about the rights of the under trial. Let's first go across to our correspondent who's tracking this story closely. In fact, let's listen in to my colleague Harish reporting on the proceedings in court. Harish.
A huge relief for social activist Teesta Setalvad as she will be coming out of jail after spending in fact more than 2 months, in fact 2 months and 10 days in the custody of the Gujarat police, and the Supreme Court has said that she shall be made to appear before the trial court tomorrow, and whatever conditions have to be imposed that has been left by the Supreme Court to the trial judge. And she also has to surrender the passport. And coming to the factors which the Chief Justice led bench had considered while granting her relief is that the fact that she is a lady who has spent more than 2 months in the jail, and also the allegation allegations against her are pertaining to fabrication of documents or tutoring of witnesses, and it's not a very, during the hearing the Chief Justice Lalit said that they are not very grave charges like POTA or UAPA, and also she is not anymore required for a custodial interrogation, because even Solicitor General Tushar Mehta, who had appeared for the Gujarat government, admitted that she was subjected to sustained interrogation for seven long days. And also the Supreme Court considered the fact that the High Court, while handling her bail application, had, after issuing notice to the Gujarat government, adjourned the hearing for 6 long weeks. And Supreme Court even questioned whether this was the set practice, set procedure in Gujarat, whether such a bail application the hearing of such a bail application is adjourned for more than 6 weeks. It means around for 1.5 months. So Supreme Court considered all these factors and said that at this stage, till the trial is completed, Teesta Setalvad is entitled to get an interim bail.
Right. Harish, thanks very much. Namit Saxena, advocate in the Supreme Court, is joining us here for an expert view on this issue. Good evening, Mr. Saxena. Good to have you with us on the program. I want to begin by asking you that the Supreme Court has raised a number of issues. Why it was unfair on the part of the Gujarat High Court to delay the next bail hearing. The observations almost suggested that as if there was a deliberate delay. Now, what exactly is the violation here in terms of where the bail should have been granted, and where and why did the delay happen?
See, once an accused prefers a bail application, the procedure is that you issue notice to the public prosecutor through the state, invite objections, and then, as soon as possible, or objections in form of status report or action taken report, and you decide the bail matter as expeditiously as possible. Now, in this case, what the Gujarat High Court did was, the bail petition came, it issued notice, called for objections or the status report, and then posted it after 6 weeks.
Yes.
So 6 weeks is a very long period, because see, every single day, every single, hour rather in jail, is costly. Not only on the accused, but also on the public exchequer. So for 6 long weeks, you're putting, the bail hearing. This is something which is very inordinate. So the Supreme Court took very strong note of it, saying that, that is why we are releasing her on interim bail immediately. That after 6 weeks, whenever the date is there, you decide it on merits. We are not touching the merits at all. But during this period, she has to be released on bail. This is what the Supreme Court primarily said today.
So, Mr. Saxena, if I understand this correctly, if it was not for the top court's intervention, Teesta Setalvad would have been in jail for another 1.5 months till her bail hearing, her regular bail hearing comes up. This is only interim relief.
Yes, she would have been lodged in jail otherwise. Because see, once she has already applied for bail, there is no interim protection given to her by the High Court. Now, during pendency of this bail petition, she can't file another bail petition before the High Court. So till this is disposed of either way, she can't file a second bail application. So you take her right away, that she can't lodge a second bail, and you have postponed it for 6 long weeks. So this is something which is very inordinate, and Supreme Court took very strong note of it, which in my view is correct.
If you notice, the fact of the matter is that the same Supreme Court had earlier made observations based on which the Gujarat government argues the arrest was made. The bench at that time said that the disgruntled state officials, along with others who conspired to keep the pot boiling. The court, did not really suggest anything, but it did make those observations, which the Gujarat government is now citing. However, now the top court says that she's not been booked under UAPA or any other grave offence which could not merit bail.
See, when the Supreme Court made those observations in that judgment, the Supreme Court did not say that, what all offences can she be booked under. Now, it is the investigating agencies or the state's prerogative. Now, a state invited, or perhaps put her only under normal IPC offences and not under UAPA offences in their own wisdom. So when this bail petition came before the Supreme Court, there's a change in circumstances now. The circumstances then were that the Supreme Court was only, tracing it to the government's wisdom, that, that these are, disgruntled opinions, and there are certain things which the state government may look into. Now, the state government looked into it and put certain in the normal IPC offences and not under UAPA. Now, when this bail petition, interim bail petition came before the Supreme Court said, okay, no, you may have, in your wisdom exercised only, only IPC offences.
Yes.
But she is entitled to interim bail till the High Court decides the, regular bail either way. Now, the Supreme Court has also exercised caution in saying that, this is independent of what we are saying and unaffected by whatever findings you are giving today, if at all they can be called findings, the High Court will be free to adjudicate it on its own merits. We are not touching merits at all. What perhaps weighed in before the Supreme Court today is that one, she's a lady, she's 60-year-old. Second, this postponement of 6 weeks is something which is, inordinate in Supreme Court. And perhaps
the Supreme Court also asked Mr. Saxena, and I'm quoting the CJI-led bench here, what material have you found in the last 2 months? The lady has completed 2 months of custody. So questioning, what use have you made of this period of time? Number two, you had custodial interrogation. Is there anything you have elicited out of it? Which means that, in this particular case, the justification for custodial interrogation does not apply. Is that what the top court, you think, is implying here?
No, see, what happens is if the police has taken custody, or rather lost in judicial custody also, they have to do something which is known as custodial interrogation, that during custody, we have to recover something from you, or we have to, extract some confession from you, or we have to record whatever admissions or statements the other accused are making so as to you don't tamper with them, or, you don't, look into other evidences if you are, inside. So this is the primary objective behind taking custody of an accused. Now, what the Supreme Court asked today was that you have had her since 2 months. What is that you have done till now? What is the material available on record? What is the evidence collected till now to show that she's, prima facie guilty of certain crimes or some crime?
Right.
If you don't have that material, why should she be lodged inside jail at all? This is what, weighed in the Supreme Court
All
today.
right, Namit Saxena, I appreciate your joining us and giving us clarity on various aspects of this case. Thanks very much.
Thank you.